the US visa getting harder or smarter? Well, this is the biggest question that is on everybody's mind right now. With new policies and new rules every day, it is actually getting trickier for so many people to understand whether the system is simplifying things or making it more tighter. Stay tuned, friends, stay connected and watch this session till the end because I'm sure after watching this session, you will get a lot of clarity. Because the guest who is going to join us has expertise in the field of immigration, also has years of experience. So watch this session till the end, and the best part is you can also participate in this webinar by posting your questions on the comments section. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration TalkShow. Also, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So thank you so much, everybody, for joining us. And before going ahead, let me read out this very important disclaimer. I hope you'll keep that in mind. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. Welcome, everybody, to Immigration Talk Show, and it's me, your host, Sam. So go ahead and watch the session till the end. Also ask your friends, your family members, or your loved ones, who are navigating the complexities in the field of immigration to go ahead and like, share, and subscribe to our channel because we post very important news updates and also have these very important webinars. So now I think without any further ado, let me welcome our today's very special guest who is very insightful and very confident and a great speaker too, none other than immigration attorney Kimberley Best Robidoux. So hi Kimberley, it's been a while that we are connecting back. So firstly, welcome back to Immigration Talk Show and thank you so much for being here. How are you doing?
I'm doing great, Sam, and thanks for having me. It's good to be back and to be chatting with you. Thank you very much.
All right. Thank you so much, Kimberley. And friends, the best part is you can also get in touch with the attorney herself. And you just have to visit the link and you'll get the contact details of her. You'll get the email ID, website link, and also the contact number. So thank you so much, first of all, for being here and being participative in this session. So I think, Kimberley, today our topic is very important. And I think it is actually the biggest question, not only for immigrants, but for everybody, for basically Americans, for whole world. Like, is US visa process actually getting harder or smarter? So what's your call on that before diving into my questions?
Yeah. So at this point in time, we're seeing the immigration process being more difficult. There are some avenues underway to make it a smarter process. However, what we've seen in the last few months and what we've been experiencing right now, especially with recent presidential proclamations and the government shutdown, the immigration processes have definitely become more complex. More and more strategy is needed every day, keeping alert with everything that's happening, diving in and understanding new policies and how that impacts not only companies, but individuals and what their future processes are. So it is definitely a more complex, more difficult, and I would have to say a slightly more chaotic process right now. And as I mentioned, with the government shutdown right now, it is definitely making things way more difficult in order to predict and strategize, which requires right now a lot of different alternative options given the timing of the government shutdown and what will happen.
Absolutely, and that's very well said. And with that, Kimberley, talking about, as you mentioned, recent changes and recent policies are also taking place. So I think let's go one by one, talking about a very recent change that is a $100,000 fee update, right? So I think this is quite shocking and very much, unclear for most of the people. And specifically talking about the H-1B visa categories, I think this new update is making them very upset. So according to you, firstly, I would like to know what's your call or what's your suggestion to the H-1B visa category, and how the H-1B visa category people should look forward as the future of the USA. Will the US still be, having a opening gate for the H-1B visa category, or will the situation will be difficult for them? How is it going to be?
So I wish I had my crystal ball in order to guide people of what we expect. We definitely have a lot of uncertainty, and with uncertainty comes stress and anxiety and cautiousness, which is completely understandable. So the September 19th presidential proclamation that came out was issued at around 4 p.m. Pacific time, and which would have been 7 p.m. East Coast time, came as a huge surprise. There had been some news articles earlier that day that were talking about a $100,000 fee. And I would have to say, we all thought, oh, are they talking about making the H-1B petition a situation in which the minimum wage to be paid has to be $100,000? So when the proclamation came out, it was a total surprise. None of us had any idea. There was no rumors about it beforehand. So that became really difficult, which a lot of you may have seen the chaos that ensued for that weekend. A lot of individuals came back to the United States on Saturday, getting back to the US before the September 21st deadline, only for the government to then later that day on Saturday say, oh, this doesn't apply to people that already have H-1B status, which is not how the proclamation is written, right? So big tech companies, big immigration law firms, small immigration law firms, every immigration attorney were actually speaking with each other, collaborating with each other, talking through what was happening, and advising the clients the best that we could so that people didn't get stuck outside, right? So that was the first level of chaos. And then the next few days or so, we were trying to gather information about how this is going to impact everybody going forward. Where we are right now is still waiting for guidance from the Immigration Service. So specific written guidance has not yet been issued to clarify a lot of questions. Where we are to this point in time is that anybody who had an H-1B petition approved or filed before September 21st is not impacted by this presidential proclamation. For cases, H-1B petitions that were filed after September 21st, the government has essentially alluded to the fact to change of employers that essentially require an extension of stay, petitions that require amended status, and change of status that require the issuance of a new I-94 document should be adjudicated without being subject to the fee. The question is, does the fee hit once somebody departs the United States and is seeking entry into the US? Because this presidential proclamation was based on a section of immigration law, which is 212F, and that deals with travel, over which the president actually has a lot of latitude and discretion. So there's the uncertainty right now. For any H-1B petitions that require consular notification or pre-flight inspection, so where there's not an extension or of their stay in the US, those likely are impacted by this presidential proclamation. Now, there was a lawsuit that was recently filed in order to get to the bottom of this. Initially, we are requesting a preliminary injunction to stop the presidential proclamation going into effect. So we should hopefully hear something initially about the preliminary injunction in the next few weeks that will provide a little bit of guidance. But for now, the best thing is for people to talk with their companies and immigration counsel in order to determine a specific situation and what we see in the future. Again, wishing we had a crystal ball, but based on what we have information now, we can provide guidance and potential alternatives in the event that this actually stands up.
Absolutely. I think I completely agree with you. And those are the very important pointers, Kimberly, that you mentioned very patiently, and that too in a very detailed way. So I'll say, friends, if you have any question regarding the topic or any other doubt, whatever the conversation we are having, and these are very insightful and very timely discussion that we are having with our attorney. So friends, without any hesitation, if you are having any single doubt, whether it's of yours or your loved ones, your friends, please post them on the comment section and make sure that you are posting those questions so that we can also try to help you out. And with that, Kimberly, as you have mentioned all these things, I would like to continue. I would like to follow up my question. What do you think, like, what can be the reason behind, this proclamation? Because talking about the H1B, visa category, they are the people who are like 70% of H1B are in USA. Don't you think that if this proclamation will be I mean, if this going to impact heavily the H1B visa category, then it can also shake the foundation of the US job market? I mean, how is it going to be?
It can absolutely shape the US job market. So there's a couple of different things to consider. So with this presidential proclamation, if there is a $100,000 fee, it impacts tremendously small businesses. And a lot of small businesses utilize the H-1B program. Everybody thinks about the large tech companies that utilize the H-1B program, and they are definitely heavy users of the H-1B petition. However, there are a lot of small businesses and medium-sized businesses that hire and retain amazing workers who need that H-1B classification to work in professional positions in the US. So with this $100,000 fee, if it does come through, right, if it's allowed to stand, then that will hurt a lot of organizations in the United States. And it's because a lot of companies that are small and medium sized are not going to be in a position to pay a $100,000 fee for H-1B petitions, right? It's a significant chunk of change. And then we also have to look at it from the perspective that there are a lot of H-1B professionals that obtain their degrees in the US, either their bachelor's or master's or PhD programs. And they continue on to the US to stay here in the United States, utilize the skills and knowledge that they've gained at US universities and colleges, and create something amazing in the United States, right? A lot of entrepreneurs, and in fact, a lot of the CEOs of some of our large, really successful companies are immigrants who came to school in the United States and continued through either the H-1B process or some other program. So it will have a significant impact on job opportunities, which if you back that up a little bit, that will then have an impact on individuals saying, well, why do I want to go to the United States for my bachelor's or master's or my continued education, with a PhD, if I'm not going to be able to continue in the United States through that H-1B classification. So that definitely, this proclamation has a significant impact if it's allowed to stand. It will really not just affect small and large companies, small, medium, and large size companies, but it's going to affect universities and colleges as well, which will have that, successive impact because everything is linked, right? There's a lot of linkage going on right now. With one of the things I just have to say, like when I started with immigration law, when we had the .com boom, in the 90s, a lot of the petitions and cases I worked on were for individuals who are being sponsored from abroad. So a lot of companies were hiring individuals with degrees from India, China, and various European countries who had not gone to school here. So we had a lot of evaluations of education to prove that they had the equivalent of a US bachelor's. Mm-hmm. Fast forward now, over 20 years, the majority of the H-1B petitions that we are filing are individuals who actually gained had their education here in the US. So we don't do those educational evaluations as much anymore because they have US degrees. So that it's really changed over the last 20 years or so. And with that, that's one of the things I'm saying is it will have a tremendous impact on colleges and universities as well.
True. All right, that's really insightful. Thank you so much, Kimberly, for I'll say thank you again for joining us and putting a lot of great points to our session. I'm sure our viewers are enjoying. And with that, I can see a lot of friends have joined us. Sid Mohan has a lot of questions to us. So thank you so much, Sid. And if you're joining us for the first time, make sure to like, share, and subscribe to our channel. Our handle is at Immigration TalkShow. Then Imran is here. So I think let's take up Sid Mohan's first question. He's saying, hello, NIW I-140 has been pending since last 8 months. So what would you suggest at this time, given filing a premium might lead to a RFE, as officers might not be reading the petition carefully?
Yeah, there is some concern about upgrading to premium processing and an officer not having sufficient time in order to thoroughly adjudicate that petition within the period of time. So for NIW, it's 45 business days, and it could lead to an RFE. One of the main reasons is because an officer doesn't have time to thoroughly review or just needs to get it off their desk because they have a quota of either issuing a certain number of RFEs or a quota of adjudicating a certain number of petitions during each month. With that, I would also look at an individual specific situation. Is an approved I-140 petition needed in order to get extensions of H-1B status? Is an approved I-140 petition needed for other circumstances, right? So is that I-140 approval actually needed for a benefit moving forward with the green card process? If not, then it may not be worth proceeding with premium processing. But there's also the other side of it is I want to know sooner rather than later. So maybe that $2,805 is worth the, let's move forward with this. If we're going to get an RFE, let's get an RFE sooner rather than later and proceed with preparing the response. So I would say it really is a case-by-case situation with respect to, is there a real need for the approval of the I-140 petition, or can someone, afford to wait a little longer?
All right. Thank you, Kimberly, for your answer. And Sid, I hope you're happy with the answer. In case if you have any other follow-up, then please go ahead and put them on the comment section. Let's go ahead with the other question that I got from Imran. So Imran is asking, for people watching from India who are feeling frustrated or scared to apply, what would you tell them right now? Yes, Kimberly.
Oh, that's a good question. We're all a little frustrated, or a lot frustrated right now. There is a lot of chaos. There's a lot of uncertainty. And, as immigration attorneys, we are really doing everything that we can in order to bring some information, to relieve stress and anxiety. But like I said, we don't have a crystal ball. So there is a lot of unknowns out there, especially with the government shutdown. So my recommendation is, to wait a little bit for some of this chaos to settle down, for some more answers to be provided so that you can determine the best strategy for moving forward. Unfortunately, there's not much that we can do right now given all the chaos and uncertainty. I wish I had a better, quote unquote, better answer for people with specific information, but just given all the unknowns right now, as much as I hate to say it, it's a little bit of let's wait and see a little bit. And, we'll have hopefully more answers or more information for better guidance in the next month or so.
That's right. I think right now the situation is only to let's wait and see, because there's no confirmation and no clarification from, any side. So I think whatever happens for the best. And of course, our expert is sitting here. So friends, if you have any doubt, in case if you're not feeling comfortable to share your documents or any other things on the chat section, you can directly get in touch with our immigration attorney, Kimberley Best Robidoux. The link is here. You can visit this link and you'll get the contact details of her, and she would definitely help you out and also solve your query. So I think let's go ahead with our next viewer who has also joined us, and it is CDK. So the question is, I received RFE for my I-129 petition of my H-1B extension beyond 6th year with I-140. Is this normal, as I'm new to this update? I'm still waiting for update from employer or attorney. Yes.
So the answer, it really depends on what the reason for the request for evidence is. What is the government specifically asking in that RFE? We've had situations sometimes where, there might be an RFE and the officer is saying, what is the basis for the extension beyond the 6-year maximum period of time? And in some of those cases, we've noticed that the officer has overlooked the document in there that shows that the perm labor cert application was filed 365 days before the 6-year maximum period of time. It is not that unusual for an officer to overlook documents in a petition. or for the mailroom to actually not scan in all the documents. So a document that's essential for adjudication may not have been scanned in. So that does happen. I wish it didn't happen, but that does happen, and it has caused RFEs. There might also be confusion on the part of the officer if they're trying to determine if an I-140 petition or a labor cert were filed at least 365 days before the 6-year maximum. So they're looking to count recapture time in order to determine that. So there's a couple different reasons of why an RFE would be issued just based on a particular situation. And it might just be responding to that specific question and providing the documentation that may have already been provided, or providing additional information to back up the reason for the request to support that.
All right, all right. Okay, and there's another question, Kimberly, that we got from Sid. And the question is, when on current H-1B, what is the minimum hours to work for a second employer? How should concurrent H-1B hours be specified in petition if the hours vary per week from 1 to 10 hours depending upon employer?
I think I understand what's being asked, but what if somebody is already working in H-1B status and then they have a second employer who's filing for concurrent H-1B employment, there's essentially no specific minimum number of hours that need to be worked for that second employer. Now, the immigration officer is going to be looking at it and wondering, well, is this a legitimate job offer if that second H-1B is for 1 hour a week, right? There's a little bit of concern with if it's for an hour a week, but if it's for a part-time position and it's stated in the H-1B petition that it's for part-time 5 to 10 hours a week, then that is something that can be adjudicated and approvable as long as the petition meets all of the requirements, right? That it's approvable as filed, that it's a professional position that requires at least a bachelor's degree, and that the individual has the required qualification based on the requirements for the position. So the bottom line is there's no minimum, but you would have to look at it on a case-by-case situation. And 1 hour a week is probably not going to make it through the immigration process.
All right, all right. Okay, Richard is also here. Hi, Richard, and thank you so much for your participation. I hope you have subscribed to our channel, and if you haven't, then please do it right now, because we come up with these amazing webinars with great attorneys, and these webinars are for you guys so that you get a chance to get directly in touch with our attorneys and to help with your any problems or any complications that you're facing in your immigration journey. Okay, let's take up his question. And Richard is asking, with the introduction of the $250 visa integrity fee, reduced interview waivers, and increased scrutiny of social media profiles, do these changes reflect a smarter approach to national security? Or are they simply making the process harder for legitimate applicants? I think this is the question of the day, Kimberly, for you.
Well,
Yes.
Our current administration will argue that it is definitely for national security purposes. I apologize, I have my cat in the background. So it is for national security purposes, is the argument by our administration. We definitely need to make sure that individuals who are applying for visas and are entering the U.S. Are vetted to ensure that they are not terrorists or terrorist organizations or spies, etc., or who have significant criminal issues or significant previous immigration status violations. So that's part of the vetting process. The social media is a little more concerning at this time, especially with our First Amendment right to free speech. So there has been a lot of pushback on that. And that particular topic. So is it smarter or making the process harder? I would say part of it is to be smarter and ensure we protect national security. The other part of it is significantly to make the process more difficult for individuals who are coming to the U.S. in order to limit immigration to the United States.
All right. And I think, Kimberly, a cat also wants to be on the live show.
He does. He wants to.
You can tell our viewers what's the name of a cat.
This is Chukali. He's our 18-year-old tuxedo cat, and he just woke up from.
Okay. But that's okay. That's okay. Okay, let me go ahead with my next question. And I think this is, let's take up Chaitanya's question. Okay, so I think Chaitanya is saying thank you so much for the amazing session. I have a small question with regard to F2 case. Currently, I'm on H1B and now applied for change of status F2 due to current delay in H1B transfer. So, firstly, the question is that is it legit? And can I stay on F2 case status showing as received? Yes, Kimberly.
Oh, so if someone is changing their status, and I don't know if I caught the entire question, Sam, but I'll answer this part and then let me know if there's something I missed. So if someone is in the United States in F1 status and they're changing to F2 to be the dependent of their spouse, when that F2 application is submitted with the Immigration Service, as long as the person is in valid F1 status at the time of submitting that change of status, they are, under our regulations, permitted to remain in the US while that F2 application is being adjudicated.
Okay, all right. So I think Chaitanya, you got your answer, and thank you so much for participating. If you're joining us for the first time, go ahead and like this video and also share the link of this webinar with your friends or anyone who is navigating the journey of immigration. And this is the session that is really very interesting, and a lot of viewers have also joined us. So let's take up Shaman's question. My parents are green card holders, and my sister is a US citizen. Also, she is my petitioner, but it is so lengthy. What type of visa I can apply with my wife? Yes, Kimberly.
Yeah, so typically when there's a situation where there are multiple family members that have permanent resident status and or US citizenship, when someone is requesting some type of visa in the US, if it is a non-immigrant only visa, such as a student or a visitor, there's going to be a higher level of scrutiny to ensure that the person who's applying for that non-immigrant visa classification has the intent to return back home after their temporary trip to the US. So there definitely is more scrutiny. There's more, there's a higher requirement in order to prove via information that you put in the DS-160 application online, not documents you bring to the interview, but information you put in the DS-160 that shows that you're just coming to the US temporarily. The F1 is going to be scrutinized as well, right? Because that has non-immigrant intent. So with having family members who are permanent residents or US citizens, and if there's an I-130 petition that's been submitted by an immediate relative, that also increases the government's perception that the person applying for the visa has non-immigrant intent. So the two visa classifications that allow for dual intent, meaning non-immigrant and permanent resident intent, are the H-1B classification and the L-1 classification. And the L-1 is for intercompany transfer. So I know some people who start their career abroad with a larger organization, sometimes even a smaller or medium-sized organization that has an entity overseas as well as an entity in the US that have a related qualifying relationship, such as the parent subsidiary or affiliates. And after working in a specialized knowledge, managerial, or executive capacity for at least 1 year with a company overseas, they can be transferred to the US in that L1 classification. So I know a lot of people who utilize that process. They strategize, they find an employer that they want to work for, and that would hopefully lead to an L1 in the future. So the H and the L are those that allow for dual intent, and the other visa classifications would be really difficult to get a visa if you have U.S. permanent resident family members and U.S. citizens in the U.S.
That's right. I hope, Chaitanya, you are, Shaman, you are keeping notes of all these pointers, whatever Kimberly is mentioning. And let me go ahead with DKJ question. And friends, I think before this, let me remind you, like it's almost time. So right now, I don't think like we will be able to take up all the questions. But you keep on posting the questions, because even after the live stream ends, we will try our best so that our team will reach out to you and provide you the answers to it. So you can go ahead, post your questions, and let's see how many we can take till now. So the question is, Kimberly, like how long on average is it taking to get an AP and EAD based on AOS C9 category?
Oh, so for someone who has a pending application to adjust status and you file the application for an employment authorization document card, that EAD card, it is taking anywhere from about 3 to 5 months to get that EAD card.
Mhm.
So that's what we've been currently seeing. Of course, with the government shutdown, even though the USCIS is open, they have been, or likely will be a little bit slower or some delays the longer the shutdown lasts. But right now, it's been typically 3 to 5 months.
All right, all right. Okay, so I think, Kimberly, let's take up last question that I can see of Sid, and after that, we can wrap up. So Sid is asking that I'm in the US and plan to travel to my home country for stamping. Will those with approved H-1B have to pay $100,000 after first time visa stamping in their home country upon entry into the USA?
So at this time, if that H-1B petition was approved or received before September 21st, the $100,000 fee does not apply. And then our understanding from some guidance is that if the petition was filed after September 21st and has been approved for an extension of stay in the US, that the $100,000 fee should not apply either. We're waiting for absolute confirmation on that, but that's the understanding at this point in time. So before traveling or making those plans, I would absolutely confirm with your immigration attorney, so that you have everything that you need in order to present at the visa stamping, as well as what you need for reentry into the US. And then if anything changes on this policy between now and the travel, that can be provided so you have the best information possible.
Absolutely. All right. So thank you so much, Kimberly, for being here. It's absolutely a pleasure and honor to have a show with you. Okay, so here's a very interesting comment we got from YD Nandan, and this is, your cat is so cute. Is it immigrant or a US citizen? What do you have to say?
Well, I did adopt him from Arizona and brought him to California, so I guess he's an immigrant in California. But thank you. Yeah, he likes to participate sometimes.
But that's so cute, and it's also very beautiful. And I think, yeah, that's all for today's episode, Kimberly. Thank you so much. It was a pleasure having a show with you and a wonderful session. Before leaving, any message or any suggestion you would like to share with our viewers, then please go ahead.
Just want to say thank you, Sam. Always wonderful talking with you, and hang in there, everybody. We're all in this together. We're learning things as we go along, and we're just, doing everything possible to make this less chaotic, even though there's a ton of chaos. So we're trying to provide that information and guidance as best as we can, given the current circumstances. But hang in there. We'll get there. I have faith.
All right. Absolutely. That's so motivating. Thank you, Kimberly. Have a great day ahead.
You as well. Take care.
Thank you. Thank you so much. All right, friends. So that's all for today's webinar. I hope you guys enjoyed watching this session and have filled yourself with lots and lots of insights, whatever we have talked and learned in this webinar. So with that, I think, Kimberly, I think you can take a leave because I think your cat is missing you right now. Thank you so much, Kimberly, and have a great day.
All right. Take care, everyone.
Okay. Bye. Thank you so much. Yeah. Bye-bye. So yes, friends, and that's all for today's episode. Friends have participated here a lot, and I think there are some questions that we haven't taken, but that's okay. No worries. You can keep on posting more and more questions because it is really high time and a very tiny topic that we have been covering in this session. You can also let us know in the comment section what can be the next topic that you want us to cover or you want us to talk about. And with that, friends, also don't forget that the upcoming Monday is also a very big festival in India. That's Diwali. So from immigration team, happy Diwali, everybody. And, enjoy your day, enjoy your time with your family and loved ones. Till then, also don't forget to like, share, and subscribe to our channel, because as you're enjoying, you should also keep yourself updated regarding the world of immigration. And Immigration Talk Show is one of the best channels for that. So keep watching, keep learning, and thank you so much, everyone, for being here. Happy Diwali. I'm Sam signing off for now. Goodbye and take care.